The KOM case is actually of deep public interest. So why is there a double standard?
There is much chatter that the investigation and the timing of the release of this information is linked to the interview with Bloomberg, where Mr. Lee Hsien Yang actually said that he might consider running for president.
What are the safeguards put in place to make sure that that disclosure into the public domain does not prejudice in some way the conduct of due process, the subsequent trial, and so on that may happen later on?
A general approach is that law enforcement agencies do not disclose the names of individuals who have been or are being investigated. This general principle is subject to exceptions. One example where names have been disclosed is where the offender has absconded or left the jurisdiction while investigations are ongoing. Members may recall the case relating to P. Jia Peng and Pansuk Srivipa. The couple was involved in a series of alleged cheating cases involving luxury goods. They fled Singapore last year in 2022 while investigations were ongoing. The police released their details. A second example would be where the facts which constitute the alleged offences and the individuals who may have committed the alleged offences are already publicly known. For example, as a result of findings made by our courts, and there is some public interest in disclosing that investigations are underway. Such disclosure has to be weighed against possible prejudice to the individuals concerned. A case in point would be where, following the judgment of the High Court in the Party Liani case in 2020, police commenced investigations against her employer's son, Carl Liu, based on the High Court's observations that he had given dishonest evidence under oath. The reasons for disclosing that Mr. Lee Hsien Yang and Mrs. Lee Suet Phen were under investigation are broadly similar to the reasons why it was disclosed that Mr. Carl Liu was being investigated for perjury, except that in the case of Mr. Lee Hsien Yang and Mrs. Lee Suet Phen, they have in addition absconded from jurisdiction. It was also accurate, and to give a complete answer, to mention that Mr. Lee Hsien Yang and Mrs. Lee Suet Phen had not cooperated with the police investigations after saying that they would. The case of Keppel Offshore Marine Limited is quite different. It does not fall within the different examples I've set out. Members may not know this, but it was KOM which had made the CPIB report. The CPIB had conducted as thorough an investigation as it could with the information and powers that it possessed. It turned all the stones it could and assessed the evidence together with AGC. They concluded that they could not sustain any charges in court. The conduct had taken place overseas. Key witnesses are not available. Key documents are also not available. In these circumstances, the general policy of not disclosing the names of individuals who have been under investigation applies. The investigation relates back to that very point on which the courts have taken a view as to whether they lied or didn't lie. That is why I said the prejudice is very marginal, if any. And as for the other aspect of prejudice, that people will think less well of them, the fact that we repeat in this House what the courts have already said about them is not going to increase the cloud, as it were. They will obviously be entitled to their full rights to give their version of events, and they will be entitled to defend their position in court. My recollection is that the Bloomberg interview came after the answer given by Senior Minister Teo, and therefore even the prescience of this government could not have foretold that Mr. Lee Hsien Yang was going to give such an interview. I stand corrected, but that's my recollection of the sequence of events.